Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. But not today. I must really quickly make a video reminding everyone that when you call our firm, you are calling our intake professionals. And intake professionals, well, it's in their title. Their job is to figure out if you have a case we want to make an offer of representation on. So when you call our firm, you're like, hey, I don't want to hire an attorney. I just have a bunch of questions. I need a couple minutes, hours, whatever it is of attorney time. The response is going to be, oh, no, thank you. And I'm sure you'll get really angry about that. But let me assure you, those intake professionals are absolutely correct. When you call us seeking attorney time for free, the answer will always be, no, thank you. We run a YouTube channel with live ask and answer. We do that for free. You can post your question and we might choose to answer it. That is our free help. That is what we provide. If you are not a child, a minor, and you are looking for pro bono work, I suggest you go elsewhere. This is a business. We are doing business. We help people, and in so helping them, we make money. If we stop making money when we help people, guess what happens? We cease to exist. And then no one gets helped. Not interested. Not interested in you getting rude with my intake staff because we don't want to do free work for you. I have a variety of things I would like to urge you to do. But I suspect both the Bar Association and my partners would look poorly upon those statements, so I will go ahead and pass on doing that. Yeah, it's not, you're an adult. If you want representation, you can pay for it. If you need attorney time and there's no case, you can pay for it on an hourly basis. If you have a claim, I'm sure we can work something out. It's primarily on a contingency basis. But just being like, yeah, I need a couple hours for attorney time. No, that's not going to happen. No one racked up six figures in student loan debt to let your lazy ass demand our time. It's not going to happen. It's never going to happen. And when you demand it, I kind of want to hurt you. Don't care. This we do for free. We get you answers for free. And as someone noted today, well, there's no guarantee you'll answer my question. You're goddamn right. If you want a guarantee, pay for it. And don't pay us. Go pay someone else. Our hourly rates are fairly a bit absurd for work that's on cases that we can't win a piece of, right? So I would urge you to go elsewhere. There are many fine attorneys. Your local counsel will almost certainly be cheaper than we will. And that's wonderful. That's great. I'm thrilled to hear that you are obtaining affordable representation local to you that is a high caliber quality. It gives you good advice. That makes me happy. I do not want you to hire us on an hourly basis. The point of this conversation is not that I want you to pay us money on an hourly basis. The point of this conversation is I want you to stop calling us and asking or demanding, even worse, free work. Not interested. Go away. Not going to happen. Anyways, let's get on to the free help. We have a question here from YouTube user, The Trauma Center, A Place for Healing, who says, hi, Vince. Why don't employment lawyers like to represent you against a federal agency? Because the federal government has created an EEOC system for federal employees that is an extremely unfortunate system. They have increased the amount of work it takes to represent an employee against the federal government exponentially. They've introduced a great deal of risk and additional time requirements. It is often very ineffective. That's not true. Listen, you can help federal employees. You can absolutely help them. The reality is, it costs us as a law firm about 7 times as much in terms of our fiscal investment but also just our time to represent a federal employee against the federal government than it does to represent a private employee against a private employer. Now, we still take cases and we still represent federal employees, and I think we're damn good at it. But our pricing is unfortunate because it reflects that 7x additional cost of engaging in the federal employee EEOC process. The more government is involved, the harder and less efficient things get in most avenues of the world. So too is that true here in the realm of employment law. That's the problem. The trauma center, a place for healing. To answer your question, that's the issue. That's why. Now, there's certainly firms who specialize in representing federal employees. They are streamlined for that process specifically, and I try to send people to them when I can. Certainly. Let's answer another question. YouTube user Anish says, Vince, can you win a settlement at a hearing before trial? So you can't win a settlement, Anish. A settlement is something you agree to, but inherently there's no winner or loser. The sides reach an agreement. Now, if you mean, can you win an award, like a judgment, at a hearing before trial, I don't know what the hearing would be. Is the hearing on evidence? Like, what's the hearing for? Like, if you're going to a hearing in a state agency that's going to decide the case, sure, you can win a judgment. You can win an amount of money, no question. But there's not going to be a later trial, right? If you are litigating in state or federal court and you're having some kind of hearing along the way, maybe to decide pieces of evidence, get in, get out, so what's allowed in, some issue of law, whatever it is, right? First off, that might just be called an oral argument. So I don't really know what you're referring to as a hearing. But realistically speaking, the judge is not going to say, I decree that Anish wins $10 million, right? That's just not going to happen. Now, if it is a hearing meant to decide the merits of the case, then yes, it can happen. All right. And people use that phrase hearing in different ways, in different jurisdictions, under different procedural schemes, right? So it's hard for me to give you a complete answer here, but generally speaking, and check with local counsel, please. This is not, I can't give you legal advice. I don't even know where you are. So I can't give you legal advice based on your local laws. Check with local counsel. But generally speaking, if the hearing or trial you're going to is not the hearing and trial meant to dispose of the merits of your case, then no, you will not be winning money at that trial. You could, at any point before your case is completely over, arrange a settlement though. And certainly people discuss settlements at trial appearances all the time, and hearing appearances, and settlement conferences and oral arguments. You can talk settlement at any point during your case. So if your question is, could I settle my case before the trial happens? Sure. As long as the other side and you can come to an agreement, you certainly can. The only thing stopping you that I'm aware of would be reaching, yes, a mutual agreement, a consensus on settlement, right? Anyways, Anish, I hope that clarifies things for you. If my earlier rant or these 2 answers to questions were valuable, please don't hesitate to like, subscribe, comment down below, share the channel so it can grow. Take care.